The second panel is about to take place now is to address the issue of practice pitfalls. It's to be moderated by Rudy Luukko. Rudy is the editor of investment and personal finance of Morningstar Canada, the Canadian subsidiary of the Chicago-based investment research company Morningstar Inc. Based in Toronto, Rudy manages a team of regular contributors to Morningstar.ca, and writes on industry trends, including regulatory topics that affect investors and their advisors. He's a columnist for Toronto Star's business section, a veteran financial journalist. Rudy has written over the years for numerous general interest, trade, and institutional publications, and has co-authored courses for financial advisors. Rudy, start the panel, please.
Yeah, thank you for that introduction. It's an honor to be asked to moderate this panel, and overall, I can't think of a more topical theme for this symposium, so my congratulations to the organizers. I've been covering retail investing for an awful long time, and I can't ever remember a year when there have been so many new developments regarding how advisors should do their jobs and how they should be paid. As you know, securities regulators have implemented new disclosure requirements and issued discussion papers on reforms concerning fund fees and the standards of client care. They're also conducting suitability sweeps and mystery shopping exercises and contacting clients directly for feedback. You as advisors, along with facing unpredictable markets, you have other risks and uncertainties that you face. Namely, client complaints and lawsuits. Some are justified, let's face it, and some aren't. The best solution is to avoid giving clients a reason to complain or sue, but that's not always going to happen. Frustration with falling markets, for instance, as we've had in recent years, may be taken out on you for no justifiable reason. In this session, we'll be focusing on key questions as they relate to the risk of litigation that affect the day-to-day practice of every advisor in this room. Some of the key questions: what are the common causes of regulatory actions or civil claims? What can advisors do to reduce the chances of being subjected to them? How can advisors best prepare for an action or claim? And how effective is the current regulatory framework at protecting consumers, and it should be added, giving a fair shake to those advisors, and that is the majority, who are dealing honestly, competently, and in good faith with their clients. Let's now meet our panelists. Wade Baldwin, to my far left, a financial advisor in Calgary with Sun Life Financial, president of Baldwin and Associates Financial Services. He's been the advisor of the year for Sun Life in Calgary for 15 of the past 17 years. He holds a CFP designation and is currently the Canadian chair of the Membership Communication Committee for Million Dollar Roundtable and is a life and qualifying member of the Roundtable. Wade has been heavily involved with Advocis. He was the president of the Calgary chapter in 2007 and director of the chapter board of Advocis National, now the Chapter Leadership Council, from 2007 to 2011. He currently sits on the National Board of Directors as secretary and the chair of the Governance Committee. And now to my immediate right, Ralph Cuervo-Lorenz. He's a partner at Blaney McMurtry. He specializes in regulatory risk management and compliance matters and in all aspects of dispute resolution and advocacy. Ralph has acted as defense counsel in regulatory and quasi-criminal prosecutions under a wide range of federal and provincial statutes. He has appeared or made representations before a wide variety of courts and tribunals, including the OSC, Tax Court of Canada, Federal Court of Canada, Ontario Superior Court of Justice, and the Court of Appeal for Ontario. And that brings us to Barry Papazian, a partner at Papazian, Heisey Myers. He practices litigation exclusively and with an emphasis on insurance defense, including professional liability defense of insurance brokers, life insurance agents, and financial planners and advisors. Barry has acted in the past as chairman of insurance advisory boards with respect to discipline of life agents. He's a certified specialist in civil litigation, and he has been a participant and lecturer at numerous insurance-related programs. The format of this discussion, each of our panelists will make some introductory remarks. We'll expand on some of the points raised with questions among the group, and later we'll respond to some audience questions. Let's start with you, Wade.
Good morning, everyone. I'd like to first let everyone know that I was asked here to be part of this panel as a representative of the Career Advisor channel and how we and our companies deal with compliance on a regular basis. And, you know, when preparing for this, I was looking up to see really how much we actually deal with on a regular basis, on a daily basis, with compliance issues and regulatory issues. And I've kind of become to take advantage of what Sun Life has done for me and for us as advisors in the Career Channel. For example, as a new advisor, when they are training, they go through and cover off in just a very short morning in their training. One morning out of a 2-week training program, they'll cover off every issue that we deal with, but every issue is also embedded in the whole process that we deal with as well. So, I mean, right from something that we have to do with every single client that is not, you know, standard in the industry necessarily, but we have a brochure, a very large brochure that we have to hand out at the very beginning of every single interview or sales process or meeting with our clients. It's called a clear connection, and in this thing we talk about your Sun Life financial advisor, how we get compensated, disclosure requirements, assessing the suitability of your investments, how we accept payments, just everything that could possibly need to be covered is covered off in this. And this is a must every single time we sit down with our clients. But we are affected by this stuff without even knowing necessarily. With this clear connection, we have our mutual fund complaint forms that we have to hand out to every single client, covering off conflict of interests, covering off the do not call list, anti-money laundering, anti-terrorist financing, politically exposed foreign persons, our privacy legislation that we deal with every day, our file maintenance that we have to do with every single client, and the cost associated with all of this and the time is just overwhelming to the point where we have to hire people to do some of these things, and it takes away from really servicing and giving the advice to our clients. So one of the things that I guess I'm thankful for is that Sun Life does have these things in place for us to kind of to take care of these things, but it is still quite an onerous kind of process that we have to go through on a regular basis. So.
Well, thanks. That's an excellent suggestion right there, having an easy source of information on your responsibilities. So when we get to the Q&A period with me posing the questions, we're going to have a lot of ground to cover, complicated topic, so we're going to try and keep those replies as succinct as we can. With that, I'll turn it over to Ralph.
Let me start off by saying that in our collective self-defense, actually more in my own defense rather than Barry's, my work is mostly regulatory defense. So it's not, I don't specialize in your industry, and that can be both a plus and a minus, I suppose. But within your industry, I have acted both for defendants and for plaintiffs' clients. And that, I think, or I'd like to think, has given me a better perspective. When I put it in the context of the other regulatory defense work that I do, in terms of trying to answer what I understood was the central question that we wanted to answer today from the lawyer's point of view, which is, what can we give you today that might help you stay out of trouble? And if you can't avoid staying out of trouble, better prepare in order to resolve it with a minimum of pain, damage, cost, and involvement from lawyers. So what I did was to look at the work and the cases I've had and the cases I know about. I've chatted to a few people that do more of this work than I do, And I'm happy to announce that I managed to distill it all to two basic points. So it comes with a caveat that this is sort of theory untested, as with the presentation that was on before us, is only opinion and certainly not fact. But I think it's probably a fair representation of what's at the center of the disputes that we see in this area. So I could give you, of course, pointers about all the kinds of things that you can do and should do to avoid problems. And at some point, I stopped my list and said, no, that's not helpful. They know that already. I'm sure most of them do it. Some of it is self-evident. And that's not what I think the audience would like to hear from. You've seen a muddying, to use the same word, perhaps a mixing up, a confusion, and an evolution of the role of the financial advisor. Again, that is hardly earth-shattering. But the trouble has been, as I see it, that the regulation and the law has not kept pace with that evolution in your business. So what I see is many of you have multiple roles. Many of you, of course, have multiple licenses. You both advise at one point and you sell at another. Sometimes you do both at the same time. I frankly don't know how you do that. It is extremely difficult to manage the inherent tension between those two things, in my view. And that, to me, is at the core of the disputes that I think people in your profession can get into. And that is in confusing and not being alert enough to that tension between selling and advising. You have to manage that. It's not an easy thing, and please don't ask me how to manage that because I have no idea. But I can look at disputes and see where the advisor has sort of lost sight of that distinction in particular cases, with particular clients over particular products. And I can see the result from that, which is usually trouble, because someone will be suggesting that they did too much of one and not enough of the other. Again, because of the evolution of your profession, you get a multiplicity of standards out there. Again, I don't know. If I were in your shoes, I have no idea really exactly what standard of conduct I'm going to be held to on a given day with a specific client, with a specific type of product in a specific jurisdiction. All those things are, as I see them, unclear and difficult to follow. I have nothing to suggest with respect to that other than the work that I know Ed and your organization is already doing in terms of lobbying for change, clarity, and probably, in my book, some standardization across the board, I think would be obviously helpful as well. So that is my first insight. My second insight here has to do with just how assessing in each case, again, I think that is the difficulty really, is that each case will be different. Not only because the client is different, because the product will be different, because the circumstances of the client will be different that time he or she comes into your office from a year ago. So all of that requires, in my view, that you stop each time and ask yourself the very basic question, but how professional do I need to be? Now, that's an odd way to put the thing, and I wouldn't say it out there in the streets. But I do think it's a central question that needs to be asked, and the answer isn't obvious. So, I mean, each instance will require you to act differently with respect to the elements that we all know are part of being a professional, about loyalty to the client and being free of conflicts and being mindful of confidentiality and keeping self-interest in check and so on and so forth. We all know what that is about and what that requires of a professional. Where I think things can go wrong is when the advisor doesn't stop to assess in that instance, because it'll vary. In that case, in that instance, how professional do I need to be? Am I at the top end of the range where really self-interest cannot come into the equation at all and I have to find a way to advise this client accordingly? Or are you at the bottom where you're really just taking orders and processing things where it really doesn't matter? You're really just that. And many of you sort of swing between that range or spectrum on any given day. So, as I see it, no wonder that there are times where you just don't get it right. You're not standing in the right spot in the spectrum with respect to that client. And it's not because you don't know how, it's not because the law is unreasonable, it might be because the law is a little unclear, but it certainly is because you didn't stop to just ask that basic question. It's almost a checklist exercise. What do I need to be concerned about in this instance with respect to how professional I need to be? I'll leave it at that. Thank you.
Thank you. A couple of great high-level points there, and we'll get into a little more detail on those. Over to you, Barry.
Probably what has happened is that there's been an evolution. There's no doubt about it. The last, I would say, 12, 13 years in terms of the emphasis on compliance and from the point of view of the insurers and the dealers, and also from the regulatory agencies like MFDA and FSCO that I'm familiar with. And there's a good reason why there is this trend to higher level of compliance requirements and a higher level of supervision. There's been two, at least, major events in the last 12, 13 years that you're familiar with in the early 2000s, and then the 2008 situation where the markets came down almost by a third, and on some products even much more. So, and throughout this evolution, there's been also a higher level of participation in the markets by relatively unsophisticated people. And the reason for that is because for the last 7, 8 years, we've been on a downtrend in terms of returns that people have been familiar with, GICs. So those are two sort of backgrounds that you have to keep in mind. The other issue that we have is that, as Ralph has said, there is, you know, we've got life agents who are, many of them, I don't know the percentage, but many of them are also active in the markets in effect as MFDA registrants with relationships with dealers, and there's a lot of interesting aspects to that in terms of the training and the expectations when you're selling insurance versus you're selling investment products. You know, and then there is the overlapping when you're dealing with seg funds and universal life in the insurance world, and then you're dealing with mutual funds. And then you have this word called suitability, which has emerged and is sort of has a growing strength in everyone's mind. And it's hard to really deal with, hard to define and work with. You've now got also judges who are, because of what's happened, people losing money, they go to see a lawyer, and you know, we need to work, so we get going. Like every industry except the doctors, there's always a life agent out there and a financial advisor who sees how he would have done things differently. In his case or her case, it would have been done perfectly. And there would never have been a problem. He or she would never have had that client because they would never have been able to overcome the tension that Ralph mentioned, and that is the sales part of your function, and then the conflicting expectations in that regard. So to show you where this trend has been going, in terms of insurance, you all know that FSCO and the review committees are looking more and more at introducing methodology to the suitability tests, let's say, whether it's through some kind of format of KYCs. I saw that recently. I think they were sending out questionnaires to life agents to ask about best practices and to seek. But ultimately, I see there's a trend there towards a similar documentation of that exchange between client and advisor, dealing with risk tolerance, knowledge, you know, assets, and so on. So that's happening in the insurance field. But in the MFDA world, and I don't know how many of you are active in that area, it's getting very, very aggressive in terms of both the review of the complaints that are coming in, which are automatically logged by the dealers. The minute they get a complaint, bang, the dealer tells MFDA. MFDA has got the first level, which is just what do they call it, assessment review, and then it's going to investigation, and they're very aggressive. I have to say that they're very, very aggressive. Just to give you, having said all that, I will illustrate it by a questioning I attended with a client a few days ago on DSC charges. Now, the SC charges involved in this $300,000 placement were about $12,000, $13,000, and that's gone into enforcement now. So it's no longer leveraging or those kinds of obvious areas of concern, but it's getting down to the nitty-gritty of what records have you kept, because they've elevated the record-keeping requirements for things like DSC. And are they adequate? And then my final comment, is sort of thought-provoking, is that my experience when I'm representing financial people, advisors, including life agents, is that one of the first surprises they have is how little support they're getting from their dealers and companies. Very little support. Essentially, you're on your own.
Common sources of misunderstanding is our first question topic, and we've already touched on, I think, some of the misunderstandings that can occur between clients and their advisors. So I want to ask first about common sources of misunderstanding or conflict between regulators and advisors.
I think the biggest problem is really expectations. And there's several sides to it, but the advisor really, most advisors, even the ones that end up with lawyers acting for them, most of them, for them it's not visible what they did wrong. They thought everything was fine, and unfortunately there is a complaint, and the complaint is, I've never really had a case where someone has made money in a complaint, so you know, there's an adversity, there's a loss, something's happened, and the problem is the expectations. The regulatory people have they're not out in the field. They're not dealing with the people out in the field, with the clients, with the whether young or older, whether couples or widowed or single. It doesn't matter. They're not out there, and they have very high expectations. And the financial advisors they have to deal with the clients' expectations. The clients expect, they're not going to go anywhere with you if you don't have some kind of a product or a sales pitch that's going to improve on their return that they've experienced through, whether it's a term deposit or a GIC or whatever they're used to. So you've got that expectation, and introduce in the middle of that the fact that you've got the financial planner dealing with this higher level of expectation of the clients and forced to deal with tax issues, estate planning issues, insurance issues, investment issues. And that's a big project for anyone. And when you're dealing with the regulator and the judge, let's not forget the judges. Very few judges understand insurance. Very few judges really understand investments because they've been, most of them have been on the bar for a while, or their background is different. Most of them have not looked after their own investments, so they judge you harshly. And so the major area of conflict, if I can summarize it, is expectations. Just be aware that the regulators are expecting you to be, right now the mood is you've got to be very compliant, and you can't just say, well, wait a minute, I opened an account and my branch manager was fine with it, and compliance didn't, what's the word?
Object.
Flag it.
Yeah, flag it, that's the word I was looking for. So that's not going to save you.
Okay, Wade, sources of misunderstanding between regulators and advisors? Any
Right.
thoughts on that?
I mean, I think really the biggest problem I see here is that the regulators have never worked as a financial advisor. They don't have any background. It was mentioned this morning, Robert in his panel mentioned, really to fix part of this problem is to get somebody with actual advisor experience on there. They're putting out rules for us to follow, but they don't know how it affects us. And ultimately, it affects us dearly on a daily basis. They can't put themselves in our shoes because they've never worn them. We're vilified, and in effect, we're being victimized, in my sense, because we're painted with that same brush to say we're all going to do bad. Everybody out there is going to sell the product that's going to make them the most money, and everybody's going to be painted with that same brush. And unfortunately, that's not for most of us out there. We're giving proper advice to a client to make them be as successful as possible. We work on a very different compensation structure at Sun Life. We work on what's called level commission. So we don't get the big upfront heap commissions in most cases, especially on the insurance side of things. So I do say that to my clients. I say, based on how I get paid, the longer I have you as a client, the more money I'm going to make off of you. I want you to be happy. I want you to succeed. But unfortunately, we have all these rules that are put down on us that make it difficult to run our day-to-day practice, to see those clients and do what's right for them, because we don't have as much time for it. So with this level commission structure and working with the clients with this career advice, working with the clients for a long period of time, perhaps that'll tone down the victimization of us. But ultimately, really, the big problem is that they don't see it from our perspective. They have no idea what we go through on a daily basis, and they're putting more and more and more rules in on us. And that's really the source of conflict between us and the regulators.
It just occurred to me, just back to MFDA, if you've had that experience, that's not even the association representing the financial planners. Essentially, the name tells you everything. It's the Mutual Fund Dealers Association. So that's one of the fundamental issues. If you ever have an MFDA-related issue, you'll learn that you're just judged by, an association you don't really feel like you belong to.
You don't belong to it.
And, well, you do. Indirectly, you're an approved person, but you're right.
Barry, you mentioned about the judges. They don't do their own. They don't understand these products themselves. I don't believe that the regulators understand the products either to the depth that they need to. But they're just making our lives difficult.
Well, three things inevitable, I guess: death, taxes, and disputes with clients. So so where do we go from here then? That you try and resolve these as amicably and fairly as possible. And so my question is, what are the keys to promoting early and cost-effective and fair settlements with clients when disputes do occur? Ralph, can I bring you in on that?
Sure. And let me just add something to the tail end of what we just said. With respect to disputes with regulators, I mean, I agree with everything that's been said. And so I would have put it just slightly differently. I would have said regulators come at you with a cookie-cutter approach. And there's all kinds of reasons why that happens. You can criticize resources, ability, interest, whatever. But that's what you face when they walk in and want to look at something you've done. So what that tells me, and this is what we always recommend, is it really pays to spend the time at the beginning, at the outset, before they form an idea in their mind as to what you've done wrong or how you run your business or what you're like, whatever. But right up front is that you take the time to explain, in the case at issue, how you do things and why you did what you did, right off the bat. They need to understand, as Wade was saying, what you do on an everyday basis and how you do it before they get too far down their mental exercise of assessing whether you complied or didn't comply with something. And if you spend the time out front, I can't promise you this, but 8 times out of 10, you end up much better off at the end. And often the investigators will appreciate the fact that you've taken the time because it makes their job easier ultimately. Now, many of them are not open to it sometimes, admittedly, I know that. But I think it's certainly worth a try. So that's with respect to regulators. Now, just returning to the topic about how to try to head things off before they go too badly. I mean, this is really just motherhood type stuff. I don't have anything particularly useful to say. The proof is in the pudding. So I always say to clients, you do first your own assessment of whether you have screwed something up. That's the first question. Don't get defensive. It's a natural reaction. Everyone will have it. But you can sometimes sort of paint your own self black if you get all defensive, because regulators and investigators are trained to look for that. So if you look and feel guilty or sound guilty or are doubtful as to whether you're guilty, guess what the investigator is going to think the minute he sits down across the table from you. So it's worth your while, again, to spend the time up front, so beforehand, to try to figure out what you've done wrong, if anything. And again, I suspect in most cases, the answer is things are not as bad as someone is suggesting, either the client or the regulator. The rest is really motherhood and apple pie, really. It does pay to be upfront, to be forthright. If you have screwed up, then by all means just say so. I mean, our mothers all taught us that, but we sometimes lose sight of that. Own up and say, I'm sorry. Now, your lawyer, it won't be me, but it won't be Barry, I'm sure, either, but some other lawyer might have an issue with that. But I think the world is changing in that respect. It doesn't have to be an admission of liability. It doesn't have to be anything like that. It simply has to be, and I'm sorry to a client that you've done good work for over many years. And they no doubt appreciate that work. It's just in this particular instance, something has gone wrong, and if it was because of something you did or didn't do, then simply say so. So don't get overly, it's going to sound weird coming from me, but don't get overly legalistic about the whole thing, right? If you respond to a complaint or a concern by climbing up, by saying it's out of my hands, it's got to go to compliance, I can't do anything, lawyers won't let me say anything, before I talk to you, you got to sign a release, all that kind of stuff, it's just escalating the thing. Now, there will be some instances where all of that is appropriate, but I suggest to you that's in the minority.
Barry, what's the best thing that you can do for an advisor client once he's come in and said, I'm being sued over...
Well, sometimes, I mean, there's OBSI, I think, does a relatively good job early on. The only problem with that is that, again, you are not included. I don't know if you know that, but it's the weirdest thing. You have a process where the dealer and the clients are involved, but the financial planner does not participate. And the financial planner is just finding this out. So you've got a potential situation where it's a good process. I think that can be improved upon if OBSI survives, that the financial planner also be involved in that process, and or his directly or through representatives. Beyond that, the very, very, because of the flagging, and I don't know if it's the same thing for insurers, whether an insurer that receives a complaint, let's say about a seg fund or whatever, does it have to right away notify fiscal, for example? This flagging rule is scary because it takes away the opportunity that Ralph was talking about to resolve things. All of a sudden, you're in the hands of this outfit that has never sold anything and never really had to deal with the pressures of expectations.
Okay. What are some of the things that advisors can do to reduce their exposure to liability? Wade, you talked about a few of those in your initial remarks, and are there any points that you'd like to expand on?
Really, I think the biggest issue is document everything. You got every time you meet with a client, you have the same process. You do In my case, I do the clear connection, the brochure, go through everything. It's the same process from start to finish. Once that process is finished and the client is gone, document the notes in the file. I do it mine electronically, so I'll sit down with my assistant after each and every client and say, this is what has been discussed. These are the points that we need to follow up on. This was the client's attitude. This was the client's comments. If you document everything and your process is the same every time, I think that's probably some of the best stuff that we
Your
can.
process, are you taking notes if it's a phone conversation or in person or whatever? Are you recording the conversation? What is it?
No, I don't record the conversation, but it's mental notes for the most part. There is some physical notes during, fact finds, those kind of things that are written, but I think keeping those notes is extremely important because when it comes time to, and I've never really had any issues on this, apart from a couple, but that were dealt with before. I mean, you talk about this actually, you deal with certain issues that come up.
You don't have to confess everything.
You deal with certain issues. It's on this, what you guys were mentioning before. If the initial complaint in most cases is going to come to the advisor first, and if the advisor deals with it and goes, geez, yeah, I really screwed up here. We need to make this right before it gets to the point where it has to be taken to that next level. So, if we document it, and in my case, I've had 2 E&O claims in my career, and they were both segregated fund things. One was a technical computer trading screw-up that was done, and another was a point inside of a information folder that was not clear, but was pulled out at the end. It's called a late deposit reduction. For those of you that do seg funds, in every seg fund contract out there, you may not be aware of, but there's a clause in there that if a client is 75 years or older, if they die within the first 3 years, the 100% death benefit guarantee is only reduced to 80%. It's not clear, but make sure you read it. It's in there. Every single seg fund contract has it. But realized after the fact that I did not know about that, and the client came to me and said, geez, we're going to sue if this isn't rectified. Okay, we screwed up. Contact. It's all documented there, and dealing with it properly, we ended up putting an E&O claim through, and it was dealt with before it gets to the lawsuit stage. And if you do it honestly and admit when you're wrong and deal with it, it's going to save a lot of grief.
Thanks. I think we all appreciate the candid disclosure, and I want to disclose that once or twice in my career I've made factual errors in my articles. And they were done.
Those are opinions. Those are opinions.
Some of the more topical issues of the day. Yes, you have a follow-up, yes?
I just want to add something to
Okay.
that. From the perspective of the judges, and I think also from the regulatory perspective, and from your own when you're looking at somebody's work that's being complained about, I think the most important is knowledge. Now, what I mean by that is, whether you're doing a needs analysis or objectives review, a lot of insurance have those formats now, or forms, or you do a KYC, then you get into risk tolerance and all that vague terminology. But it really comes down to the one that you have to identify the extent of knowledge. That's where the courts are, that's where a judge starts from, ultimately, and everything else matters or doesn't matter depending on that. So if you have a product, so if you have someone, because that also objectively, that's the easiest one to test. I mean, it doesn't take a genius to see someone, maybe the spouse who was looking after the investments or the products had a very good knowledge or a good knowledge, but the surviving spouse or the whatever other spouse doesn't have the same extent. So I've seen KYCs where it's a novice or very little knowledge, and yet the product is fairly sophisticated. That's not going to work, and because everything else ultimately comes down to having to justify that this product is understood by this person. If you can't, and that is the only security you have. If you can, because matching the high expectations to an unrealistic level of knowledge is not going to work. You're getting a product that's wonderful because the person can have very little knowledge and yet wants, a good return, a good product. Oh, this sounds great. So here's what I've got for you. Which do you want? Which do you like? Well, of course, everybody wants this one. The last thing they're thinking about is losing money because they've never lost money quite yet. So knowledge is the most important.
Okay, thanks. I want to turn to a couple of the big regulatory topics. One of them was the fees debate touched on, and I want to leave also time for audience questions, and apparently, cards can be brought up, so I think we were down to our last 15 minutes. So I want to keep these replies short and to the point. On the fee, the great fee debate, I've called it in my articles. Two-part question, brief replies, please. What do you expect to happen with the fee debate on embedded compensation? Secondly, what can advisors do to prepare? So, Wade, can I start with you on that?
Okay.
Yeah.
Let's start with the lawyers.
Yeah.
So, the question again.
Just any kind of speculation on what you think, how you think this is going to play out, the embedded compensation debate? You're allowed to say, I don't know. I mean,
Ultimately we don't know, but I mean, we would hope that it doesn't get to that stage. I mean, if we already have an issue recruiting people into this industry. If we now eliminate embedded commission and compensation, and how difficult is it going to be to keep advisors in this business? People aren't going to write a check. People are not going to write that fee. In order for me to give you financial advice, you need to give me a check for $3,000, $4,000, $5,000. People are just not going to do that. So people are not going to have access to advice, and the amount of advisors that are recruited into this business is going to get smaller and smaller and smaller, which means our access to advice is being limited. Okay. So I really hope that this doesn't go much further than where we're at right now. And of course, at Advocis, we're working on some alternatives to some of these things. But I really hope it goes not much further than the discussion that we're having. Okay.
Barry or Ralph, any predictions from either of you on which way this is going to go, and how advisors might brace themselves, or are we a little premature at this point?
I really don't know much about this topic, except I can tell you, in any litigation, in any complaint process, it really surfaces, because the way it surfaces as a big issue is, I had no idea. The reaction is, I had no idea that my life insurance advisor was paid so much, and I have no idea that this is what my financial advisor. So that becomes a big issue.
But it's often, those kinds of things are usually said by the client, the same client that doesn't read their statements or anything else you sent to them. So I don't see that issue as coming up a lot in litigation. And especially now that I saw the presentation that went up there on the screen before the break. I mean, I think it's less of a problem than that you might think in terms of regulatory issues and civil litigation. So, but on the policy side, I have no idea.
I want to get to the fiduciary area, and I have some time for audience questions. And actually, one way to get at this is through a question, and one of them is directed to you, Ralph. Can you please expand on the conflict of an advisor who advises and sells? Do you see a problem if a proper analysis is acknowledged by the client and a product is purchased to fill the gap identified in the analysis. You can have it.
All right, well, it's, the conflict, what I mean by that is it's, and I hope I didn't say conflict, it's more the tension. And it happens in all professions, I think. It certainly happens for lawyers as well. So let's say I have a case, and I would really want that case to go on for 10 years because I'm going to be getting nice fees from it for 10 years. But really, my best judgment is telling me that you really need to drop the case tomorrow. That is my best advice to you. That is the best advice I can give you if I divorce it from my own self-interest. So there's that tension there. And I'm going to have to resolve it, and hopefully we all resolve it in a professional sense, and that means that I'm going to tell the client you have to settle that. So similarly, when you have a client that you're selling, certainly a multiplicity of products. Obviously there are some where you'll be better compensated than others. And there'll be some where they are more or less suitable for that client in the particular circumstances of the client. It's the same issue as in my simple example that a lawyer faces. So I say to you, just stop and think for a second. Really at bottom, what is the motivation and what should be the best advice? We can all do that exercise and we all reach the right decision in the end, I think. The trouble happens when we don't stop and sort of think for ourselves at that point before we give the advice. Okay. So, sorry, I missed the second part of the question. Do I see a problem and there's a proper analysis? Sorry, if a proper analysis is acknowledged? No, I don't. And that goes back just a very quick sort of practical best practice that hasn't been touched on, and I'm sure many of them do it, and that is confirm things to clients. Lawyers are paranoid about that for good reason, and I suggest that everyone should do the same thing. Every time you speak to a client or meet with a client, do a quick bullet point type of exercise. You said this, I told you that, and the to-do list for the two of us is X. That will catch the miscommunication that is often behind these problems, and that might be the point at which you raise an issue like this to whoever asked the question.
Okay, thanks. Rapid fire questions here. We got quite a few. Hope to get to all or most of them. Barry, I'm going to throw this one at you. At what point is there a line drawn between consumers' responsibility to determine products they need and purchase and the services, and the advisor's fiduciary responsibility to provide and advise clients to appropriate products and services? Now, of course, in the retail space here, we don't really have that fiduciary standard right now officially. We have the suitability standard. But anyway, how do you respond to that on the degree of responsibility question?
I mean, unless there's fiduciary requires as a threshold question, threshold feature, discretion. I mean, if you take on any kind of discretionary or take a situation that of over-reliance on you, then you become more of a fiduciary or in that level, and the expectations, the standards, everything skyrockets. But beyond that, I mean, you've got a public that's getting very well educated, especially with people like you writing constantly. There's a lot of, but I think this takes you back to my comment about knowledge. The agent's self-defense has to be, okay, this person sounds like they know what they're talking, or they seem to understand, but have they ever had a self-directed plan of some kind? What have they done in their background? Have they lost money before? What kind of what situation, what kind of insurance have they had before? So you really need to test their experience and knowledge, and if it's anything sophisticated you're selling, really the best defense, I think, is to involve another professional. Not the lawyers, because you don't go to a lawyer for something like that. But if someone if it's sophisticated, then no harm in saying you have an accountant. Anyone that has an accountant who can refer to an accountant, that illustrates the level of sophistication. Get the accountant involved. That gives you some protection.
Have regulators or courts become more or less sympathetic to clients in recent years? That is, are they treating advisors more harshly lately? And I think I'm going to go to this side of the panel for a response. Any trends you notice?
I read a case that it's called Strauss, and I think it's IPC, and 2010 decision. And the judge was very sympathetic to the claimants. And the reason was this particular situation. Right away, the judge saw that the advisor really shouldn't hold himself out as a financial advisor. He had very little training, and the company behind him, you know, they'd done some stuff, but so the selection of the advisor in that case was criticized. The experience, the training of the advisor was, and then the extension into areas beyond the core licensing areas was criticized. Anytime you end up in front of a judge, you can be sure that the sympathy will be with the claimant. They have a grievance, and then it'll be your job, our job, literally to reverse that presumption. I don't care what the law presumption is, but it's a reality. You'll have to reverse it.
Do you think it's in the event that a fiduciary standard would be imposed, would that be, that would be welcomed? I know in some quarters of the investor community, you see a lot of the consumer advocates presentations taking that stand. Is that in the best interests of investors, of advisors?
I don't think so. I really think, first of all, I can't imagine having a blanket like that. You have to have the basis for it. You can't make somebody a fiduciary if they're not in fact a fiduciary. Mm-hmm. I mean, you have to start with that, and because you cannot, by regulation, change, in my opinion, change what the whole law of fiduciary, you know, several hundred years of law of fiduciary is, and it's founded on elements of being a vulnerable person, relying on the person that you're working with, giving discretion to that person. So those features, I mean, it's a judgment call. You could have, so there's no labels on this, so you just can't make every life agent or every financial advisor a fiduciary.
Okay.
There's no way it's going to work.
Okay. Thanks. Our time is up. Thank you for your attention. Thank you for your questions.